directions. The first part of my directions are directions to obviate discrimination. Counsel for the petitioners and some counsel for the respondents advanced extensive submissions on the various forms of violence and discrimination that society and the state machinery inflict upon the queer community, and especially queer couples. This has been discussed in detail in the prefatory part of the judgment. Counsel sought directions to obviate such violence and discrimination. Now my directions. A. The union government, state governments, and governments of union territories are directed to 1. Ensure that the queer community is not discriminated against because of their gender identity or sexual orientation. 2. Ensure that there is no discrimination in access to goods and services to the queer community which are available to the public. 3. Take steps to sensitize the public about queer identity, including that it is natural and not a mental disorder. 4. Establish hotline numbers that the queer community can contact when they face harassment and violence in any form. 5. Establish and publicize the availability of safe houses or garima grahs in all districts to provide shelter to members of the queer community who are facing violence or discrimination. 6. Ensure that treatments offered by doctors or other persons which aim to change gender identity or sexual orientation are seized with immediate effect. 7. Ensure that intersex children are not forced to undergo operations with regard only to their sex, especially at an age when they are unable to fully comprehend and consent to such operations. 8. Recognize the self-identified gender of all persons, including transgender persons, hijras, and others, with socio-cultural identities in India as male, female, or third gender. No person shall be forced to undergo hormonal therapy or sterilization or any other medical procedure either as a condition or prerequisite to grant legal recognition to their gender identity or otherwise. B. The appropriate government and the Mental Health Care Act must formulate modules covering the mental health of queer persons in their programs under Section 29(1). Programs to reduce suicides and attempted suicides envisaged by Section 29(2) must include provisions which tackle queer identity. C. The following directions are issued to the police machinery. 1. There shall be no harassment of queer couples by summoning them to the police station or visiting their places of residence solely to interrogate them about their gender identity or sexual orientation. 2. They shall not force queer persons to return to their natal families if they do not wish to return to them. 3. When a police complaint is filed by queer persons alleging that their family is restraining their freedom of movement, they shall, on verifying the genuineness of the complaint, ensure that their freedom is not curtailed. 4. When a police complaint is filed apprehending violence from the family for the reason that the complainant is queer or is in a queer relationship, they shall, on verifying the genuineness of the complaint, ensure due protection. And 5. Before registering an FIR against a queer couple or one of the parties in a queer relationship, where the FIR is sought to be registered in relation to their relationship, they shall conduct a preliminary inquiry in terms of Lalita Kumari versus Government of UP to ensure that the complaint discloses a cognizable offense. The police must first determine if the person is an adult. If the person is an adult and is in a consensual relationship with another person of the same or different gender, or has left their natal home of their own volition, the police shall close the complaint after recording a statement to this effect. Conclusions and orders of enforcement. In view of the discussion above, the following are the conclusions. This court A. This court is vested with the authority to hear this case. Under Article 32, this court has the power to issue directions, orders, or writs for the enforcement of the rights in Part 3. B. Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. C. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. D. Marriage has attained significance as a legal institution largely because of regulation by the state. By recognizing a relationship in the form of marriage, the state grants material benefits exclusive to marriage. E. The state has an interest in regulating the intimate zone to democratize personal relationships. F. The issue of whether the Constitution recognized the right to marry did not arise before this court in Justice K.S. Puttaswamy, 9 judges, Shafin Jahan, and Shakti Vahini. G. The Constitution does not expressly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, several facets of the marital relationship are reflections of constitutional values, including the right to human dignity and the right to life and personal liberty. H. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws, such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The court, in the exercise of the power of judicial review, must steer clear of matters, particularly those impinging on policy, which fall within the legislative domain. I. The freedom of all persons, including queer couples, to enter into a union is protected by Part 3 of the Constitution. The failure of the state to recognize the bouquet of entitlements which flow from a union would result in a disparate impact on queer couples who cannot marry under the current legal regime. J. In Article 15.1, the word sex must be read to include sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because the word sex is used as a marker of identity, which cannot be read independent of the social and historical context. K. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation. L. The decisions in Navtej and Justice K.S. Puttaswamy, 9 judges, recognize the right of queer couples to exercise the choice to enter into a union. This relationship is protected from external threat. Discrimination on the basis of sexual orientation will violate Article 15. M. Transgender persons in heterosexual relationships have the right to marry under existing law, including personal laws which regulate marriage. N. Intersex persons who identify as either male or female have the right to marry under existing law, including personal laws which regulate marriage. O. The state must enable the LGBTQ community to exercise its rights under the Constitution. Queer persons have the right to freedom from coercion from their natal families, agencies of the states, including the police and other persons. P. Unmarried couples, including queer couples, can jointly adopt a child. Regulation 5.3 of the adoption regulations is ultra vires the Juvenile Justice Act, Articles 14 and 15. Regulation 5.3 is read down to exclude the word marital. The reference to a couple in Regulation 5 includes both married and unmarried couples as well as queer couples. The principle in Regulation 5.2a that the consent of spouses in a marriage must be obtained if they wish to adopt a child together is equally applicable to unmarried couples who seek to jointly adopt a child. However, while framing regulations, the state may impose conditions which will subserve the best interest and welfare of the child in terms of the exposition in this judgment. Q. In view of the interpretation of Regulation 5.3 of the adoption regulations, the issue of whether the CARA circular disproportionately impacts the queer community no longer arises. R. The union government, state governments, and governments of union territories shall not discriminate against the freedom of queer persons to enter into union with benefits under law. And S. We record the assurance of the Solicitor General that the union government will constitute a committee chaired by the Cabinet Secretary for the purpose of defining and elucidating the scope of the entitlements of queer couples who are in unions. The committee shall include experts with domain knowledge and experience in dealing with the social, psychological, and emotional needs of persons belonging to the queer community, as well as members of the queer community. The committee shall, before finalizing its decisions, conduct wide stakeholder consultation amongst persons belonging to the queer community, including persons belonging to marginalized groups, and with the governments of the states and union territories.